another child that, you know, if you put $100 in his pocket, he's spending 110.
Right.
So how do you protect your children after you're gone? And to make sure that, you know, that they're taken care of too.
So when a prospective will client, if you will, comes through your door, sits down with you, there's a lot to talk about here before you ever pick up a pen to start to write this.
Yeah, I'd say usually the initial consultation could last, you know, at least 45 minutes to an hour.
I see.
And one of the biggest things now too is the blending of families. A lot of times you have somebody come in and they have children from a previous marriage. They get married and they have children, or their spouse, their new spouse has children. Well, how do you distribute those assets evenly amongst all the different children and to the surviving spouse while still protecting the rights of your own children?
Yeah, good point. Isn't it true, Ken, though, that actually most people don't have a will?
I get a lot of people that come in that are, you know, later on in life, and you know, 40s and 50s isn't later on in life, but that's usually a time when they've accumulated some assets, and you know, they finally come in and says, you know, we've been talking, and it's time that we
time to have one.
Put together a will. Most people that come in, you know, after somebody passes away, I think people now are becoming a little more sophisticated, and most of them do have a will, but I'm sure there's a good majority of people that have never thought about it, and it's not really the most pleasant thing in the world to think about.
But it sounds like a pretty important thing to have, though.
Oh, definitely.
I mean, it's going to make things a lot easier when the inevitable happens to all of us. When you have one, you've prepared it. What's the best? I wrote the question on it. What is the best place to keep your will? I mean, unfortunately, you won't be the person using it when the time comes. So what do you do with it?
Well, we offer a client, we actually have a fireproof safe in our office, and we will offer the client the option of keeping the original in our safe.
Oh, so you would have it, I mean, when the inevitable happens, assuming you're going to be the person that works through the probate process, the will's there.
Yeah, we have the original will. Plus, the problem can become is if somebody does take it home and they don't tell somebody that, oh, by the way, I put the will up in the attic behind the, you know, behind some loose boards. You know, if that person's passed away, obviously they can't tell anybody where their will is. Some people do have an area where they keep all their important documents, but they do need to tell somebody, you know, where the will is at.
Kind of a housekeeping type question, but an important one, because a person was, shall I say, responsible enough, I guess that might be one way of saying it, but hired you, put this all together, tried to make sure everything was arranged for assets to go to the appropriate children, and if nobody knows where it's at, it's not going to do any good. So that's really does make sense to have it. Certainly you have your lawyer or some person who's going to be your administrator, which we'll talk about, or executor, know what's that. Ken, is there really, like you see on television, is there really a reading of the will?
I know of some lawyers that still do that will bring in the beneficiaries and actually read the will. The problem I've found with that is because we're in a society where people are so mobile, you might have some of the children living out of state. You might have them, you know, down in Florida or out of the country. So I generally don't have a technical reading of the will. Usually my first letter to them is, you know, sorry to hear about the passing of your father. I'm including with his, you know, father or mother, I'm including with this document a copy of the will.
There's a copy of the will.
And, you know, so that they've received a copy of it that way.
Well, I mean, I've seen enough plays and movies where, you know, it's
very dramatic.
Very dramatic, but I guess it doesn't exactly work that way. But it's a good point. And you know, all of our families now, we have people. Our world has gotten smaller. I mean, people live all over the place, and that might not be too proper.
I actually had a beneficiary of a will once that was a missionary, and he was a missionary in South America. So to get him documents, we actually had to send the documents to Florida. From Florida, they went by boat over to South America. they were loaded on a horse or a mule, taken to the village and delivered the documents there. Then they had to reverse the order back,
Come back to you,
and come back to me. So, you know, to ask him to come in to
it wouldn't be too practical
to read the will, I don't think he was going to do that.
That's an interesting story, Ken. Ken, what's the difference between an executor and an administrator of a will?
An executor is usually the person named in the will. A part of a will is, besides the distribution of the assets and stuff, is naming a person that you want to handle the estate. Usually in a husband and a wife, the husband or wife will pick the other party out as the executor, and as a substitute will name somebody else. If somebody, and when you probate that will, you also ask that that person be named executor of the estate.
Okay.
An administrator usually is somebody, if somebody dies without a will, they make an application to administer the estate, and the court has to approve them. Usually an executor is pretty automatic. I mean, if it's named in a person's will, courts generally don't like to disrupt what a person wants to do in the will. An applicant has to be somebody that's related, generally related to the deceased person, and an administrator is not as free to do what they want. Usually in a will, they have broad range of powers. They don't have to apply to the court to sell real estate. They don't have to apply to the court to do certain other things. An administrator is more bound by the law as to what they can and can't do.
What happens, Ken, if you had a family that there was no, now I understand, I guess the executor, that was all predetermined and you wrote it into the will, and you know, I know in my case, my son will be my executor, but what if you got a couple of siblings and they both apply?
If they both apply, then normally the court would hold a hearing and determine who is best suited to administer the estate.
Could get a little acrimonious, couldn't it?
Oh, sometimes it can. Everybody wants to believe that their children will get along after that they pass away, but sometimes it just doesn't happen.
I see.
And there are some children that are better suited to administer an estate than others. And it's just that the court will have to listen
Judge
to what each one has to say, and the court, the magistrate, or whoever is doing the hearing has to make the
call.
They make the call who they believe is the best person to administer the estate.
I see. When you hear the term, and I know you hear it all the time, when somebody says we have to, or a lawyer says, or anybody says, when we have to open an estate, what does that mean?
A lot of probate work is form driven. To open the estate is where you start to gather that information and you put it on the court's forms, and it's basically telling the court, you know, who the deceased person is, you know, when they passed away, where they lived or where their domicile was, who the beneficiaries, either the natural beneficiaries would be like children, things like that, and who was named as beneficiary in the will itself. And also you have to, when you open up an estate, you have to give the court a rough idea of what the assets, or what the value of the assets are. When you open an estate, that it doesn't have to be a perfect number. That happens later on. You can say, you know, we believe the estate is worth, you know, $125,000. It's kind of an estimate. When you're doing an inventory later is when you have to be more precise what the estate. And that's generally when the will's probated or admitted to probate, and you open the estate. That's the beginning of the estate process generally.
Okay. This would be a job that is probably best suited for a lawyer to do?
I believe so. There are a lot of forms that you have to fill out, and you know, most people think, oh, it's just a form, you just throw in a number, but that's just not the case. You have to determine, one, is it an estate asset? Does it belong in the estate? You have to figure out which form it goes into. There are certain things that you have to serve upon beneficiaries. There are certain things that you have to do, and